we need to ask a basic question here at the 25th anniversary. How did Congress choose the 12 rights that they did, and what are the basic things that you want our audience to know about what the Bill of Rights protects?
The most basic thing, and I've already given you some hints about it, we'll just play a game. And some of you have played this game with me before, so if you have, don't spoil it for the others, because you will know the answer to this. But I'd like folks in the audience just to shout out the names of the famous, when I say Bill of Rights cases in American history that pop into your head, whether you agree with the outcomes or not. The big, famous Bill of Rights cases are, just shout out their names.
Dred Scott.
Dred Scott.
Gideon versus Wayne.
Gideon. Brown. Roe v. Wade, I heard. Marbury versus Madison. Griswold v. Connecticut. Brown v. Board of Education. New York Times v. Sullivan. Citizens United. Zenger. Now, I can't fool this crowd. It's a very sophisticated crowd. And that said, half of the cases that you shouted out are not Bill of Rights cases. So first, Zenger is before the Constitution. Marbury versus Madison is about original versus appellate jurisdiction, and who cares? It's not any great principle of liberty. Dred Scott is about the fundamental right to have slaves or something, but yes, that actually could count as a Bill of Rights idea. But here were landmark cases that you tossed out, and strictly speaking, they're not Bill of Rights cases. And I'll add a few more. Gideon versus Wainwright. Griswold versus Connecticut. New York Times versus Sullivan. Brown versus Board of Education. Roe v. Wade. Lawrence v. Texas. Miranda v. Arizona. None of those is a Bill of Rights case. Tinker versus Des Moines. Why not? Because the Bill of Rights originally applied only against the federal government. Congress shall make no law of a certain sort. And the 10th Amendment is about states' rights. And in between, there are celebrations of local juries and local militias. The original Bill of Rights was an anti-federalist, Tea Party, localist suspicion of the central government. And that's important, but that's not our Bill of Rights today, because you believe, with Madison, that some of your most fundamental rights need to be protected against states and localities. Brown versus Topeka, Board of Education of Kansas. Gideon versus Wainwright is Florida. Roe versus Wade, whether you agree with it or not, is Texas. Lawrence versus Texas. New York Times versus Sullivan was an effort by Alabama to shut down free speech. Miranda v. Arizona, again, Griswold versus Connecticut. Most of the cases that ordinary people think of as Bill of Rights cases aren't Bill of Rights cases, because the amendments are only about limiting, the original Bill of Rights, limiting the federal government. So, what kind of cases are Gideon versus Wainwright, and Lawrence versus Texas, and Brown versus Board of Education, and New York Times versus Sullivan, if they're not Bill of Rights cases? You now know enough to know the answer. What cases are they? They're 14th Amendment cases. No state or localities, which are part of states, shall make or enforce any law which shall abridge these fundamental rights. That's the second founding, a second Bill of Rights, the one that actually is more intuitive for most Americans today, because states misbehaved, because Madison lost when he tried to get that original 14th Amendment passed, saying no state shall violate fundamental rights. But the Senate didn't go along, so he lost that fight, but he wins in the end thanks to the 14th Amendment. And it's utterly apt that we give Madison the credit for the final 14th Amendment, but it's also a little bit ironic, because all of this is precipitated, this 14th Amendment, by the slaveocracy's abuse of power. And alas, Madison and Jefferson were charter members of that slaveocracy. They founded a political party whose base was basically a Southern base that benefited hugely in the Electoral College and elsewhere from the presence of slavery. Because of the 3/5 clause, Jefferson and Madison and their party is going to get extra electoral votes every election because the southern states that are voting for them are getting extra seats in the House of Representatives and therefore also in the Electoral College because of the existence of slavery, because of the so-called 3/5 clause. So it's both, ironic and apt. But our Bill of Rights does descend from Madison, but through the 14th Amendment, through Lincoln.